Time up. All right. So where were we? We were basically at the point of that this notion of applying versus making law is something that had a logic to it when it first originated, but we have subscribed to it in a much more rigid form in the modern context. But when you start examining it in the modern context, it is even less plausible to say that judges are simply applying the law, in that it's not even precedent that they are dealing with, it is also statutory interpretation. So when we give the judges the authority of being the final arbiters of meaning of law, we are we are investing the judges with enormous authority in our system. The question is, why is it that in the entire universe that we occupy in modern times, the judges have this particular capacity or capability of being the only people who can tell you what is the meaning of any law? Okay, forget about making and applying the law. We've set it aside for the time being. Why do you think in common law systems we give so much authority to the judge? This is it. Huh? They have the experience. Okay. Anything else? How come they cannot be there? We just said they don't make law, they apply the law. I get it. I understand what you're saying. Yeah. But that's different than just focus on that any statute has to be interpreted for us to come to some kind of a decision as to what is the meaning of this rule. So Parliament has made the rule, and it is the judge's business to tell us what is its actual meaning. So when you are in front of the court, you at least have two interpretations, right? You could have more than two, but at least two interpretations are there, and that's why we are in the court. And now we're telling the judge, you tell us what is the meaning of this rule. Why? That is true, but it's not only a question of convenience, because what we are saying is that the legislature has made the law, has made the rules. Surely they knew what they were doing. So why do we need another party to now tell us what is the meaning of this? Are you getting the problem that I'm trying to put forward to you? That here is a legislator, perfectly competent, has made a rule. Let's only deal with that they've made this single rule. And now we are in front of the court and saying, you tell us what did the legislators mean. It's not only that we can't go back to the legislators and say, tell us what did you mean. There's something more going on here. What we are saying is that the meaning of the rule is what the judges are going to tell us. Why? Sonali is saying because they have the experience. What was the classical understanding of the judges telling you the meaning of the rule? All right. So yeah, that's correct. But do you see that in classical common law, the tussle is between the judges and the king. So our conception of law is that law is not something made; it is already there. We just access it, and the judges are saying we are the ones who can do it, not everyone else. Why not everyone else? Okay, the king saying, it is my law, I know what to do. Who are you to tell me that I cannot? This is my realm, this is my law. Why can't I apply the law? It is a tussle between two branches of the political system. The judges, and this is Cook comes in, he's saying basically, of course, Your Majesty, you have access to reason, you can reason, but this is not about natural reason, this is about artificial reason of common law. So what is this artificial reason of common law then is that only judges have access to it. So artificial reason of common law is not only that they have the expertise, that it is much more complicated than that. So now they are saying that this is a special expertise which only the judges have. Why? Because they immerse themselves in the processes of reasoning like a lawyer. You've heard that word before, that phrase before, think like a lawyer. What does it mean to think like a lawyer? Basically, no normal person would think like that. Huh? What does it mean? In the court of law, you don't just get up and say that this is what I think. You say that you have to formulate an argument in the legal way of thinking. What is that legal way of thinking? So this concept, what process? How will you do it? You? No, you only think from your client's side. Your business system. You only so that you can counter it. Yeah, so you're not, definitely as a lawyer, it's not your brief to speak from both sides. It's only that I want to argue in the best interest of my client. In the process, I will anticipate what the opposite side is going to say and I'm going to counter it. There is no claim that I'm going to be objective. My role as a lawyer is to be able to do the best for my client. But the point that I'm making here is that so you're not going to say that I'm son of so and so and that gives me the authority to do that. That doesn't take you very far. So what takes you far is that you're saying that there is precedent backing my thing. Yes, absolutely. So this is the point that legal reasoning, the concept of legal reasoning is basically what distances you from normal things. And the origins of it lie in the tussle between the king and the judges in an ancient time in a different geographical and a political system, and we are living by reference to that. With the consequence that engaging in legal reasoning absolves you of having to worry about anything. So legal reasoning is artificial reasoning. It's not your natural or normal reasoning. And judges are bound by that, and they are absolved of any responsibility for what the consequences of their decision are. Why? Because they're not making law, they are applying the law, and they are bound by the law. In all these steps, the law is a object that exists somewhere and the judges simply access it. True? True? How can it be true? What have I been talking about for the last 2 hours? So my personal responsibility is taken out of the picture. It is the law that is doing the whatever is happening, and that means that if there is the outcome is unjust, then change the law. But go back a few steps, and we were saying that what is the meaning of any law is ultimately dependent upon what the judge has to say. Do you see how circular the whole thing is? if you see that, can you still subscribe to this way of thinking from today onwards? The point being, I'm not making your life difficult. The point being that I'm trying to show you that the function of thinking about law in this manner is that it basically allows the existence of a system that is less than perfect. So you go to the court. So remember, as Amita said earlier on, in earlier times, in original sort of when common law is coming into existence, what were the judges doing? There was a dispute, there was a problem, it needs solving, and they solved it. By reference to what? By reference to people's practices. So there was a connection between what the judges were doing and what the people were doing. So this is called the organic conception of law. That is, the law is something that is basically coming from the practices of the community. Fast forward to modern understanding, and where does the law come from? It is not coming from the community, it is not the practices of the people, mostly it is what the statutes, what the legislators are saying. And what do the judges do? They apply the law, but in applying, quote unquote, applying the law, what are they doing? They are interpreting. They have to interpret. There is no other way. But with interpretation, they are using the fiction of that basically I am engaging in a process of legal reasoning. My hands are tied. So why are my hands tied? Because it is my responsibility to reason in the legal manner. Why? Because that makes it possible that my interpretations will be objective interpretations and not subjective interpretations. So all of you can have confidence that this judge will apply the law as it is because they engage in legal reasoning, and that means that the outcome is then bad luck if you don't like it, but it is not nothing to do with the choices that the judge is making in choosing one interpretation over the other. All right. If you no, I understand. Yeah, but if we say it like it is, then what happens to the legitimacy of the law? Why would I agree to be bound by a law which is basically a peacemaking device between these two powerful groups? That undermines the legitimacy of the legal system completely. Nobody would be willing to live by that legal system because it is openly said now that it has nothing to do with fairness, it has nothing to do with my rights. What about that imposing order and doing justice and the fairness of it? If the law is not doing any of those things, then I feel no sense of obligation to this. But what happens now? Parameters are the same, but the consequences are very different for the winner and the loser. From the perspective of the loser, what's good about this? So do you see the point that by taking this line of reasoning, I have absolved myself of all responsibility for the consequences. I have nothing to do with that you were got uh, you have been greatly wrong because the law says so, and I'm here only to tell you what the law says. I have nothing to do with it. Don't blame me. But the point is, the person who's suffering is suffering. So what happened to that idea that law is about justice? It's not my responsibility. Why not? Exactly. I'm only a judge. I only apply law. I do not make law. Okay, now bear with me. Do I subscribe to that fiction still? So this is the point that by using this fiction, nothing has changed. The judges is in the business of interpreting, telling you what the meaning of law is. In telling what the meaning of law is, he is choosing or very rarely he is choosing between two possible meanings. Is there a choice happening or not? So it doesn't mean that law has a clear meaning and I'm only mechanically applying it. It means that I'm giving content to the law. In giving content to the law, I'm in the business of basically what I'm saying is there's not much difference between that making sense. Now we can subscribe to the who gave you the authority to make the law. Now that's what I'm asking. That in common law systems we attribute so much authority to the judges and then feel safe by saying they only apply the law. Go behind that and see that that's not how it is. So then you have to confront the difficult question of why should it only be the judges? So your answer that it is because they are the named people is not the total answer. Yeah, they're justified in doing. But then the legislature made the law, but we don't really know what it means because I think it means X, you think it means Y. Where do we go to resolve that dispute? To the judge. Where does the judge find the answer for it? No, 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 not looking to the society. The judge then says, I am bound by rules of legal reasoning. Legal reasoning is different than normal reasoning, right? This is the point I'm asking you to think about, that this fiction of legal reasoning is what is allowing us to not confront that judges are the ones who are the most powerful people in our system, who are telling us what the content of our law is. We feel comfortable by saying that no, no, they are. So why can I trust the judge to do the right thing is because they are not doing it in their individual capacity. They are doing it as a person who is bound by legal reasoning. What does legal reasoning mean? We'll have a whole session on, but basically it means that the judge is bound by certain rules of interpretation. Can I feel safe that the judge will give a ruling which will be objective ruling, meaning it's not their subjective preference? Why not? If every time I turn up to a court and I have to worry about what the judge's politics is, what the judge's preferences are, I would not go to the court anymore. Right? We go to the court because we believe in the fiction that the judges will give us an objective interpretation. Where does that come from? Where does that confidence come from? Is from relying on this notion that judges use legal reasoning. What does legal reasoning mean? That they have a process to follow. So here is a precedent, here is an authority, and this is what it is saying, and this is what I am going to do. But as we said a little while ago, it's never the case that there is only one stream of reasoning. There's always more than one. And I'm not suggesting for a minute that judges are in the business of doing the wrong thing all the time. No, the point of this discussion is to show you that our confidence that judges can be relied upon to give us the ultimate interpretation of law is a false confidence, and it is generated by using concepts like that judges are bound by legal reasoning and that judges are using rules of interpretation. Like Amrita said, when rules of interpretation have to be used, where do you go to decide which rule to use? The rules themselves don't tell you. So there is a whole, if you like, a collection of rules of interpretation available. As a judge, you still have to make that call, which rule of interpretation will I use, and there is no ultimate higher authority that validates your choice. So choices are being made at every step by the judges in giving us interpretation. So the point of the discussion is for us to recognize that the function of this idea that judges can be relied upon to tell us what is the real meaning of law is to make us feel comfortable that the judge is doing the right thing, that they have access to a truth which is, if you like, structured by things like legal reasoning and rules of interpretation. Now, what was the corresponding idea in classical common law was basically that judges can be trusted to apply the law and not the king, because judges had what was called artificial. I want to make this point very clear that what was the artificial reason of law in classical common law is not what we are talking about, that judges are using legal reasoning now. Okay, in classical common law, the judges had the artificial reason of law. Why? Did anyone pick up on that point? No? Why do the judges have and not the monarch? So this is a tussle between Cook and the king, and basically Cook is saying, Cook is the judge, he's saying to the king, you can't do this, only I can. Why can I? Because I have access to artificial reason of law and you don't. So what is this artificial reason of law? Did you pick up the phrase at all? No? Okay, can you mark it for yourself and go and have a read before you go to sleep? It won't take you a long time, but it is a fascinating idea. Basically, what I'm trying to get at by showing you the comparison between what artificial reason of law is saying and what legal reasoning is saying is that artificial reason of law is saying that judges are not making the law but declaring the law that already exists. As we saw, what we said was that basically law is practices of the community. So there is a connection between the community and the law. It is a organic connection, and the judges are simply accessing it through having the the practice, the familiarity, the technique of basically finding out what any particular role is. So what is the judge doing is not then making the law in the sense that we understand it in modern terms. So the argument that Davis is making for us is that in classical common law, the judge is basically using artificial reason of law, but our concept of law is very different. That is, law is not anything that the legislators say. Law is basically the practices of the community, the principles that are accepted by the community. So in that setting, for the judges to be able to access that those understandings, at least to me, makes sense. Fast forward to modern understanding of what is our understanding of law now. Is it something that reflects the community practices? What is the positivist understanding of law, which is our dominant understanding of law? Legislators make the law, so anything that can be called a law is something that has the right. So in most democratic countries, it is the parliament, if it has the authority to make the law, it can make that law. Can it make any law if it has the authority, or is it constrained? Yeah, but what I'm trying to get at is, say something is constitutional and the legislature decides to make a law, meaning do they have unlimited authority to make any law that they like? Is there any restriction on the legislature that they should only make fair laws, or they should only make just laws, or they should only make good laws? Is there any such restriction there? That's a different thing. I get what you're saying, but that's not really not relevant here. But basically what I'm getting at is that the positivist understanding of law is that if the parliament has the authority, that is, it's not unconstitutional, then it can do what it wants. There is no understanding that the parliament will be making good laws, making moral laws, making just laws, making fair laws, etc. constitutional yes, full stop. This is a very different way of thinking of law than the classical common law, which was basically community practice. So when the judges in that context are finding or interpreting law for you, that's very different from when the judges are doing it here, because there is no safety net available that the laws that are made are actually connected to the community. Parliament can make any law. British Parliament that is not even bound by a constitution. Basically, what is the saying that goes that British Parliament can declare a dog to be a cat or something like that, and nothing stops them from doing that. So it is in that context now we are saying that judges can basically only apply the law. So where is the check and balance? That separation of powers was supposed to enforce for us. Not really, because Bill of Rights has to be interpreted by the judges. Sorry, I didn't say how to consider judges, but only with the constitutional limits. That's right. And also those constitutional limits are to be interpreted by the judges themselves. So the contrast that I'm trying to make is that the modern concept of law is that law can be totally sort of not connected to the community, can be imposed from the top, and then we have a conception of the judicial authority which is saying we only apply the law, we are not responsible for what are the consequences. While in classical common law, when the judges said we only apply the law, there was a more holistic understanding of how the judges fitted in and how the law and community fitted in, because law was not something that was being imposed from top up. Very much so. So that is that is. Yeah, but not even. Yeah. So and this is the point that on the one hand there is independence of judiciary, on the other hand there is no real check on what they're going to interpret. Okay. Now this notion that they apply the law is basically a false notion, and we have to face up to it. If we face up to it, we have to then struggle very hard to think of a reason why judges should have this much authority in our legal system. And if you don't get like how much authority our judges have, compare it to what the civil law judges are doing. They are also resolving disputes, they are also applying statutes, but they don't have quite the status or quite the authority that common law judges have. And why is all this happening? Because we are subscribing to the doctrine of precedent, and we are subscribing to this notion that make the law and apply the law are two very different things, and we have complete confidence that the judges only ever apply the law. And in modern context, how that is enforced is by using the concept of judges engaging legal reasoning and not your and my kind of reasoning. Why is the right thing to do? Does anyone want to respond to that? They're two different things, very different things. And the dowry example is a good example in that um, even if 90% of the people, I'm not saying it is, but even if 90% of the people, men and women, are in favor of it, it still does not make it justified that the 10% of women can be um, exploited, burnt, or whatever else in the name of that this is what the community wants. So the one point that community and majoritarianism are two different things. The other point is that even when we want to say that there is something seriously wrong with the practice, where do our values come from? So I and you wouldn't have a lot of difficulty in saying that there is something seriously wrong when you are burning young women in the name of practice. Okay? The judges are also people like us. They are? No? Why not? So what happens when you put on the judge's robe? You are then reasoning as a in a legal manner. So whether it is good or bad is not my business. My business is to apply the law as it is. Do you see how the artificiality is coming in and absolving the judge of having to take responsibility for the outcome? I'll give you an example which is a very stark example, but I think it will capture the point here. In Australia, basically the constitution uh, um, did not include Aboriginal people as citizens. The provision in the constitution was then amended, and it said that the Commonwealth has the power to make laws for Aboriginal people also, or something like that. The exact language I don't remember. The matter ended up in the High Court, which is the highest court of the country, and the government and the council of the government were arguing that and this is the constitution that has been amended to say that Aboriginal people, laws can be made for Aboriginal people. The government council in the High Court is saying that this clause means that the Commonwealth government, that is the federal government, has the authority to make laws either for the benefit of Aboriginal people or to the detriment of others. Do you get the point? Really? Do you get the point that it is like, can you imagine those council and those judges going home and sleeping comfortably? Because here in 20th century, highest court, the most privileged sections of society are actually arguing without blushing that your constitution can be interpreted that it authorizes making the racially discriminatory laws for Aboriginal people. You and I, we can do it in open. Neither would those people. They can only do it when they are adopting the persona of a legal thinker who has to do legal reasoning. They can distance themselves from the consequences of that interpretation because it has nothing to do with it. Do you see the point that this is the function of thinking of law as abstracted knowledge? If we had adopted the position that law is really about construction of knowledge, then no one would have the option of giving an interpretation like that. So the theoretical ideas have very real consequences. For a 1% minority of the population that is totally denied their rights, here is the highest court, and two of the judges actually agreed with that interpretation. Law is about justice, law is about fairness, but what about those people? And all this is happening without having to take on the responsibility that those judges, those thinkers, those commentators are the ones who are justifying this manner of argument. So ideas have power, ideas have consequences. So let's not pretend that ideas are kind of a luxury that we can engage in. All this has very real consequences. What else? So I did send you the outline of lecture 2. So can you just tell me what are the topics that we have covered in that? There is one topic remaining, but I will ask you to identify it for me. You guys are looking a bit sleepy, that's why I'm doing this. Yes. No, that was last time. I'm asking today. I'm asking today's outline for lecture 2. Okay, I'll come to the conclusion. But basically, what we have covered, just to recap, is what is classical common law theory? How is it different from modern common law? And we've gone through what are the consequences of using classical concepts in the modern context. They totally do not fit the modern context. And why do we need to classical common law is precisely for this reason, that if we are using concepts of classical common law half-heartedly, then this is what is happening, that the modern conception of law is nothing like the classical conception of law, but we are saying that the judges have the same role to play. And the things that we have talked about common law are declaratory theory of law, that is the judges declare the common law rather than make it. So, and we've discussed all that, make versus apply distinction. We've talked about whether common law is oral or unwritten law. Not really, but you know the distinction. We've talked about artificial reason of law, right? And what is the modern counterpart of it is legal reasoning, but they are not exactly the same. So we have to be alert to the distinction between what was understood as an artificial reason of law and compare it to what we do under the rubric of legal reasoning used by the judges. And now that precedent and judges apply and change the law we have talked about, what are the critiques of common law? This is the last point that we have to discuss. So this is what the common law philosophers are saying. There are others who do not agree with it. What is their problem with common law? So the argument is that judges get too powerful under this conception. Yeah. Good. Anything else? Okay. What else? So there are two critiques that are presented to you by Davis, one by Bentham and one by the realists. So realists are basically saying that all this is nonsense. Judges are always exercising political authority, and to say that judges are applying the law is just pretending something that doesn't exist. Davis actually doesn't agree with this critique. Why doesn't he agree? So this is, you understand that realists are saying nothing like what you are saying, that judges apply the law and judges are objective and the rest of it. And surely we have been saying that to a certain extent also. But the author of the book, Margaret Davis, is actually not agreeing with this. Why is she not agreeing? I can give you the page if you like. Very good. Thank you. So critiques of common law theory and practice starting from page 64. Basically, I want you to read on page 66 at the bottom of the page. So one of the arguments is that common law method is inherently retrospective. That is, what what does any rule mean is basically decided once you go to the court. That is, the court tells you that this is the law. So because there was no earlier statement of what the law is, meaning that the law is being declared after the act. If that is the case, then it is a commonly accepted idea that justice requires that you should be judged by rules that are already in existence rather than rules are made after the conduct. Surely that's right. So the criticism by realists is that common law theory makes law retrospective. What is Davis? What is the author's response to that? He's basically saying that is a modern criticism. That is, this idea that law has to be made is how we in modern times understand the law to be. What is the classical understanding of common law? No, but it was always declaring the law. So at least at the conceptual level, at the level of ideas, what the judges were doing in classical common law was declaring the law. So that is the point of declarative theory of law. That is, they were not making the law. Since they were not making the law, there's no question of law being retrospective. Retrospective, yeah. So the only point Davis is making is that you have to always be clear that classical common laws understanding and the modern common laws understandings are quite different. So for the realist to be critiquing common law for being retrospective, it can only apply in the modern context. It cannot apply to the classical common law aspect of it. What is Bentham's problem with common law? I'm sure all of you have come across Bentham before. Okay, what's his problem? Sorry, louder please. Basically, he's saying, how do I know anything exists? Because until the judge tells me that there is a precedent that exists or this is the meaning of any rule, then what is law on any given point at any given time is dependent upon what the judge says. So what is his solution to the problem? He says, scrap all the common law rules, all the precedents, and codify the law. So you can see the shades of civil law thinking coming in, saying that if you state your statutory rules clearly, then you don't have to rely on judges to the same extent that we do. So that is the big difference between common law and civil law, and Bentham is kind of leaning towards the civil law model that state your rules clearly, and then your judges are not so powerful as they are in his understanding of common law. One problem with this understanding is that even in civil law countries, judges still need to interpret the rules. So common law judges need to interpret. They are who Bentham. Yeah, definitely. But that's taken for granted that he is. So his his critique then is that basically make your rules clear. All right. Having made the rules clear, the judges still need to interpret them. The difference between judges doing that interpretation in common law jurisdictions and civil law jurisdictions is that in common law, what the judge has to say then constitutes the body of precedent, while in civil law it doesn't. So what's the issue here is reliance on precedent. So Bentham's argument that there should be codification then has to go hand in hand with that we do away with the doctrine of precedent. Do you get the point? That we are so imbued with the idea that law is about precedent that when somebody suggests that maybe you can think of law as something different, that precedent is actually not required, our imagination doesn't go that far. This is the function of ideas being dominant by force. Like because we are common law lawyers, we cannot imagine a universe of law where precedent does not exist. All right. Dworkin is the last thing he's talking about. What is the point of Dworkin's discussion? You remember Dworkin's theory of law? Somebody did mention the chain novel. We'll have occasion to talk about Dworkin later, but very briefly what he is getting at is that law is not only rules of law, it is a combination of rules of law and principles. So where do those principles come from? So when you go to the court to ask the judge to make a decision, the judge is not only applying the rules of law, she's also free to choose which principles would help make a decision. Where do those principles come from? Can you find them somewhere? Dworkin basically is not saying that there is a collection of them, or that you can go to a book or you can go to a source, etc. Principles are what already exist in the air, if you like, and the judges know what those principles are. Is there a harking back to common law understanding of what the judges were doing? Not only applying the local customs but also using principles from basically how the people live their lives. Basically, what that citation is there for us to show you, this is what Davis is doing, is saying that judges, not only in classical times, but even in today's times, and this is an Australian case, are basically subscribing to this idea that judges only apply the law, do not make the law. So that's what that example is used for. You got it? So it is actually a critique of that idea by the author, saying that this kind of easy reliance on the notion that judges only apply the law happens even now. It wasn't like it only happened in the past. So what is the point of Dworkin's discussion here is, Dworkin is an author who's basically trying to say that positivist understanding of law is a little bit limited, and really we need to understand law as more than just legal rules. It is a combination of legal rules and principles. So what is the task of the judge? The task of the judge is to give the best decision possible. How do you know something is the best decision? Is by his concept of laws and integrity. That is, judges a little bit like somebody engaged in, or people engaged in writing a chain novel. So you write one part, then the next person has to take over. It is their responsibility to keep the narrative going. In other words, development is happening, but the development is not too radically going into radically new direction. So what is the function of Dworkin's theory then? Is that we can have confidence in the judges that they would make the law as good as it can be. Are you willing to go along that? Yeah, let me go home. No, that is something that we need to think through very, very carefully, in that nothing has changed. So what are the principles that are appropriate in this situation? Who's going to decide? The judge has to decide. Do I have any input into which principles the judge should use? None. So the authority of the judge is then based upon this fiction that they will do the best job possible. Why? So why do we have that kind of faith in the capacity of the judges to be able to give us? So they are modifying the law, they are developing the law, but we also want to have confidence that they will do the right thing. Has Dworkin managed to give you that confidence is the question that I want to ask. All right. So the point of today's discussion is basically for us to be very, very alert to the idea that judges can be relied upon to tell us what is the real meaning of it. Okay. Now for tomorrow you have your set of printed materials. Can I expect you to have read chapter 3, please? Yeah? Not too much reading? Yes, please.